In this episode, we will be discussing the right to self-organization for the purposes of collective bargaining. The first sentence of Article 253 of the Labor Code provides for the general rule on the right to self-organization in the labor sense. It provides that all persons employed in commercial, industrial, or agricultural enterprises in religious, charitable, medical, or educational institution, whether operating for profit or not, would have the right to self-organization for the purposes of collective bargaining and would have the right to form, join, or resist these kinds of organization. That is the general rule because, as you have noted, it talks about all employees. The exception to this rule would be found in the second sentence of the same article, when that article specifically provided that those that are employed, considered to be ambulant, itinerant, self-employed people, or those without definite employer would have the right to join, form, or assist labor organization for the purpose of mutual aid and protection only. So you will notice the difference. In the first sentence, the right to self-organization involves collective bargaining, but in the second sentence, it involves only for mutual aid and protection. So in other words, the employees listed in the second sentence of Article 253 would not have the right to form, join, or assist labor organization for the purposes of collective bargaining. There is another provision in the Labor Code which expressly prohibits a group of employees from forming, joining, or assisting labor organization for the purposes of collective bargaining, and those are managerial employees. So, under our current laws, managerial employees who have the power to exercise management prerogatives cannot form these kinds of organization for the purpose of collective bargaining for the simple reason that they are the representatives of the employer. And so, if they will be allowed to form unions, they will be placed in an awkward situation of negotiating with their own selves. Based on jurisprudence, it is not found in the law, but the Supreme Court extended the prohibition to confidential employees. The Supreme Court said that if confidential employees will be allowed to form labor unions, these labor unions will have a distinct advantage against the employer because they have knowledge of confidential information. But for confidential employees to be excluded from the right to self-organization for the purposes of collective bargaining, two elements must concur. The first is that they are holding position of trust, and second, and perhaps more importantly, the information that they have access to must relate to labor relations. Another set of employees based on jurisprudence that are completely prohibited from forming, joining, or assisting labor organization for the purposes of collective bargaining are those employees engaged or employed by international organization. As you may have learned in political law, international organizations are immune from suit. The Supreme Court said that if the international organization are immune from suit, the employees employed by them could not form, join, or assist a labor organization for the purposes of collective bargaining. Perhaps you are asking why they are prohibited when registering a labor union does not fall under the category of filing a suit against an international organization. The Supreme Court explained that when a labor organization is formed or a labor union is established, that union at some point in time will compel the employer to negotiate with them. If the employer refuses to negotiate, then the labor union would have the capacity to file a case against the employer, which is usually an unfair labor practice case, which is a criminal case. At that point in time, that international organization would be immune from suit, and therefore the employees of that international organization will not be able to file a case against it. Because the employees of the international organization will not be able to exercise the ultimate power of filing an unfair labor practice case against an international organization, the Supreme Court said might as well prevent them from establishing a labor union in the first place. Another category of employees that are absolutely prohibited from forming labor union for the purposes of collective bargaining would be those employees of cooperatives who are also incidentally members of that cooperative, meaning they are also owners of that cooperative. The Supreme Court said that if you are an employee and at the same time a member/owner of the cooperative, you will not have the power to negotiate with your employer because precisely you are the owner. Similar to the situation of managers, if you are the owner of an organization or of a cooperative, how could you negotiate with your own self? Similar to that situation, the Supreme Court said might as well prevent them from exercising the right to form joint and resist labor organization. In the same case, however, the Supreme Court clarified that the rule on shareholders of corporations will be different. For shareholders who are incidentally employees of the company, they may have the right to form joint and resist labor organization because they will not be placed in an awkward situation negotiating with their own selves. Because if you will recall, in corporation law, the shareholders and the corporation would have separate and distinct personality, which is not present with respect to cooperatives and members of the cooperative. So essentially, those are the people that are absolutely prohibited from forming joint and resisting labor organization for the purposes of collective bargaining. There are certain classes of employees which we may discuss because there are certain rules that govern them. For example, supervisory employees. While it is true that they are not absolutely prohibited from exercising this right, there is a qualification. They may only join former labor organization amongst themselves. They cannot commingle with rank-and-file employees. For example, the foreign employees. Foreign employees in the Philippines will also have the right to form labor unions as long as, number one, they have an employment permit here in the Philippines, and number two, the countries from which they are from also provide or extend the same benefits to Filipinos working abroad. And third, security guards. Previously, there was a law prohibiting them from exercising the right, but because of the passage of the new law, now security guards may be allowed to form joint and resist labor organization. With respect to government employees, they have that right unless they have high-ranking positions or positions with the power to decide on policies, or they are in the Armed Forces of the Philippines, police, or jail guards. Other than those group of employees, government employees would have the right to form joint and resist labor organization, just that they cannot bargain on terms that are already provided for by law. In summary, all employees have the right to self-organization for the purposes of collective bargaining. However, there are certain categories of employees by way of exception that are prohibited from exercising the right to self-organization for the purposes of collective bargaining. In addition to those employees listed in the second sentence of Article 253 of the Labor Code, managers, confidential employees, members of cooperative who are incidentally employees thereof, and employees of international organizations are prohibited from exercising this right. In the next episode, we will be discussing the bars to certification election.